with a brief introduction of ma'am. So today's speaker is Advocate Anuja Saxena. She is an experienced advocate and legal advisor with the Rehabilitation Council of India. She specializes in mediation and dispute resolution, serving as a national trainer with the Mediation and Conciliation Project Committee, Supreme Court of India, and as a training advisor at the Delhi Dispute Resolution Society. She is actively involved in promoting mediation practices across India. She is skilled in legal advisory, conflict resolution, and capacity building programs aimed at strengthening access to justice and alternative dispute mechanisms. So, without further delay, we'll start with the session. I'm over to you.
Thank you, Dhruv. Thank you so much. Again, my introduction to all the participants. And I'm late again for 15 to 20 minutes, I think, because it was somewhere the slides were missing, and I wanted to share these slides with you. All the participants, last time we were discussing about the civil law, and actually the topic assigned to me was to drafting in civil and criminal matter. So in very small time, short time, we will cover of the drafting in criminal cases. Last time, am I audible to all of you?
Yes, ma'am.
Okay.
Yes, ma'am.
Yes. So last time we discussed about the drafting in the civil cases. The drafting or civil and criminal cases are quite different, because in civil matters you have to plead, like, you are just framing the matter, and criminal matter mostly you are defending your client as a state matter, or you are drafting the complaint or FIR once you are from the complainant side. So there are two ways. One time you can just file the FIR, and other time you are taking the bail from the courts. So there are different style of bails also. So drafting of all these things we have to cover in this session. Draft for liberty, legality, and process of fairness. Every allegation must be tried to statutory integration and role attribution reliable evidence. So what is required is to just have all these things. What allegation you are imposing, the way you are imposing, all the important ingredients, even the date and time and incidence of time by place of incidence. Everything is important, right? Criminal rights different because liberty, stigma, and state power are immediately engaged, right? So there are two types of matter we all know: compoundable, non-compoundable matter, cognizable, non-cognizable offenses. Depending upon the gravity of the offense, we are defining it, and gravity of the offense will cover how we are making the drafting. Because in compoundable matter, it may be a little bit civil, defending the person. We are just putting our claim or something like, because compounding is there, the possibility. So not of that style of the drafting will be there. So core drafting posture, be precise on offense ingredients, not dramatic or allegation. So what you are focusing upon, the parties, what parties have shared with you, because initially we are discussing with the parties and taking their, facts from them. Then we have to apply under which, section it will cover. And now, before that, I will just like to share with all of you, and you all are aware that instead of IPC, we have to go with PNS and BNSS and BSC. Right now, Bharatiya Nyaya Sanhita, Bharatiya Nyaya Sakshi Sanhita, all these things. So we have to have clear command over all these. Once the parties are narrating their facts, what happened with them, any kind of criminal offense, then you immediately should come in your mind under which section it will cover, and what type of ingredient you have to cover in the complaint, so that it will give the clear picture to the state authorities that the offense covered under such and such provision of the BNS. Attribute individual role, avoid collective allegation against all accused. So we should be clear that criminal liabilities is individual liability, unless there is some common intention or collaborative approach of doing the offense. So criminal liability always an individual liability. So we have to show who have done, even if it is a common intention type of performance in criminal act, then also we have to just specify the liability of each one of them. Who did what, and why he should be alleged, and why the action should be taken against them. If there are 4 or 5 criminals, 4 or 5 offenders, then you have to give the clear picture about their act and conduct, so that their manslaughter, their actors, everything, the way they have performed. Distinguish civil breach, regulatory lapse, and criminal intent. Right? Use chronology to show manslaughter, preparation, conduct, and consequences. What was the manslaughter? what was the modus operandi, everything you have to define in your complaint. Keep liberty, custody, investigation stays visible, right? Liberty first control, ground for arrest, apprehension of arrest. Cooperation with investigation. See, both sides we will work. First is once you are from the complainant side, and other side once you are, defending your the client. So ground for arrest, apprehension of arrest. If you are just drafting from the criminal side, the offender side, then you have to have the. If suppose you are moving for anticipatory bail, what is your apprehension about his or her arrest, and what could be the reason of his or her arrest? Cooperation with investigation. We should always guide our parties that they have to cooperate in the investigation. Otherwise, it will create more problem in future. No flight risk, no tampering risk, proportional bail conditions, medical age, gender, role, and parity factors were relevant. All these factors we have to have in our mind before this approaching to the any authority or the court. What offense, what role, what evidence, what risk, what relief today. Correct? So both side, again, I will say both side we are working, maybe from the complainant side or the state side or the respondent side. Under the current regime, criminal drafting must map BNS, BNSS, and BSC together. BNS 23, substantive offenses and punishment. We all know that there is substantive law and the procedural law. So, substantive offenses and punishment. What is the role of, under which provision it is covered? Offense ingredient, mens rea, accused role, punishment range. Correct? This should be our map. What should be the map? Offense ingredient. So every offense have different ingredient, and we should be clear about it. See, for the same, we have to be very clear about the provision of BNS. Under which provision it will cover. Then the mens rea, which is very important, because in Indian criminal law we always say and suggest, although this is what the Britisher has given to us and what we have redefined in the BNS, that there is need of some intention of the offender. So we have to show the what was the intent of the offender who did it. Then victim accused role, right? What was the role of victim? If you are from the victim side, and accused role, what was the role from the accused side? And punishment need. What type of punishment? I mean, this is our own skill as an advocate. Even if it is a small, if we are fighting for the complainant, then what kind of punishment we required, and we have to show this was a non-compounded, otherwise it's very heinous. Maybe it is 354 matter or 376, because these very heinous type of offense, or 302. So of punishment range. And then if you are from the side of the this offender, then you have, for his defense, you have to show the offense is not covered under the definition of the heinous offenses or non-compoundable offenses. It is mens rea was not there, or it was an the act was not of that category which should be covered under the non-compoundable matter. So both sides, we are offending and we are on defense side. BNS's procedure from information, investigation, bail, trial, appeal, and inherent power. BNS is defined. Correct procedural rule, forum, stage, relief, custody status. So, if you are into the criminal practice, we should be clear about to which court the matter will start. I mean, if it is a bail and 302 matter, to which court we have to initiate? What would be the appellate court? Ultimately, till the Supreme Court, you can fight for the FIR, but for which offense you will approach to which court, right? So, bail, from where the bail will start, that you have the drafting of the bail, and if you are on the side of the victim, then also you have to see to which court you have to file the complaint if it is a if it is a compoundable offense. Evidence rule, including electronic, digital record. We should be clear about it. BSA shows, because now electronic evidence are also important, digital records are also important. So many times we are showing WhatsApp messages, mails, any video recording, such type of thing. So there is need of such type of affidavit, which we have proof filed before the court before applying to the same to the court. These are digital record and want to show. Relevance, admissibility, burden, witness route, electronic record, certificate. So this should be your roadmap. So what is the relevance? Relevant facts. You should be clear what are the facts and what are the relevant facts. Right? Admissibility. To what extent these are admissible? Burden of proof. Who is having the burden of proof? Witness route. How you will establish the offense had happened, or how you will show if you are from the side of the criminal, that what kind of the witness you have to defend your client. electronic code and certificate. All these things we should be clear about it. Practical implication: do not file old code draft machinery. It matters initiated after this date. So after 1st July 24, you have to file your draft machinery
Ma'am, you are stuck actually. Is everyone not able to see the session?
Yes, it is not visible.
Okay, okay, okay. Just a second. I'll reach out to ma'am. Guys, just a second. Ma'am is facing some network issues. She will be rejoining. Just give us a minute.
Am I audible to all of you? Am I audible?
Yes, ma'am. Yes, ma'am. You're audible.
Yes, ma'am.
Okay. So we were talking about the document required and the drafting focus. What should be the drafting focus? So before FIR, we were talking about for anticipatory bail for any representation or protection petition. So for that, we have to clear the apprehension, the cooperation with the commitment of the offender that I will cooperate in the investigation, lack of ingredient, the facts which have been incorporated or the for which they are having apprehension of the arrest of the person. There's lack of ingredients for the same the offense and malified context we have to show before the court. FIR, early investigation, bail, fair investigation, preservation of evidence. So bail we have to approach for the court, and for the same and for fair investigation, preservation of evidence that we have to just make out before the authorities. Custody risk, offense ingredients, evidence preservation, no tampering. This is what our drafting should be focused on. What is the custody risk if he will remain in custody? Offense ingredients for the offense ingredient which require for the making the offense against the person, and evidence preservation and no tampering. He will do no tampering if in any case the bail will be granted or any further investigation or early investigation will be done in FIR. Post charge sheet, discharge, quashing, protest petition, further investigation. Material collected, contradiction, ingredient, abuse of process. Correct? And during the trial, application, objection, cross-examination note, compounding and settlement. During trial, we can just approach to the court for the compounding as well. We can file an application for early disposal of the matter. We can raise the objection also. We go for the cross-examination. All these required, the document which are required may be like this. Then we have to show the admissibility of those documents, witness credibility, and document proof trial strategy. Post order, revision, appeal, suspension of sentence, modification, order, preservably legal ground, proportional relief. So post order, if any order passed, then what further remedy are available are the revision, appeal, suspension of sentence, and modification for the same. We have to approach to the higher court. FIR criminal complaint drafting should disclose ingredients, role, and evidence without over arguing. No need of the over arguing, just give a substantive ground of the FIR. Introduction, complaint, identity, relationship with accused, and jurisdiction link. Chronology, dates, location, act, and immediate consequences. Correct? I have prepared the slide in the way if you go through the slide, even you will have all the clarity. What type of complaint, even if you are going for the FIR or the complaint, both sided will work. Introduction, complainant identity, relationship with the accused, and accused jurisdiction link. Chronology, what is the date, location, acts, and immediate consequences. What are ingredients? Facts showing each offense, not merely section label. Each offense, right? Even if it is, subsequent offense had happened, then also we have to mention in the complaint, or if we are filing for the bail, then also we have to take care that subsequent offense should also be covered. Role attribution, who did what, when, and how. This is what I have shared in the initial stage. Whenever if that more than one accused offender, then you have to mention the liability, criminal liability of each one of them separately. Evidence list, document, witnesses, CCTV, digital masses, medical exam, prayer, registration, investigation, protection, preservation of evidence. Red flag to avoid. Very important. Collective allegation against family, company, office without a specific role. It will not work. Many times in criminal matter, one person was not even there, they are including their name, which unnecessarily just making in the mind of the judges ki unnecessarily you are dragging the things and you are just including the name of those who were not even the part of the offense. Inflated sections unsupported by the facts, any section which is not have no collaboration with the facts happened. So we should be focused under which provision of the criminal law it will cover. Omitting delay explanation where delay is obvious, right? If first we are to avoid any kind of delay in filing the matter, but we always see the criminal liability will never over till that time, till the life of the person. So it will remain even if whenever it will be identified or investigated by the authorities. But if we are pursuing our client of any kind of offense happened with him, so you should avoid the delay. Even if FIR you are filing and there's delay in FIR, that also the become the reason of the settle the credibility and this dignity, this importance of the offense, right? So we should be very clear about it. Whenever there is delay, we have to explain the reason of delay. First, we are not supposed to do delay. If there is, then we have to give the explanation for the delay as well. Mixing civil recovery, language, and criminal intent allegation. Civil liability and criminal liability should avoid, because criminal code will handle with the criminal things and civil code will handle with the civil thing. So be clear about it. Civil remedies are not available with the criminal law and criminal code. So be identify if you are claim, suppose you are making the 467, 468 businesses, and there is the involvement of the big amount of money. And for the same, you have to file for the recovery as well. Here you are establishing that fraud had happened with me and the document was tampered by him. It's criminal law, so criminal liability. And in civil, you are filing for the recovery. Attaching digital material without planning authenticity and source, very important. Whenever you have to approach to the court along with the digital material, you have to seek permission from the court. You have to file certain type of affidavit that these are the authentic, and authenticity you have to be clear about the authenticity of the digital document. Drafting, if the section names are removed, do the facts still disclose the offense? Yes, my question. If the section names are removed, do the facts still disclose the offense? Yes or no? No. So this is our responsibility as a criminal lawyer, that we have to state under which provision of the BNS it will cover. A bail draft succeeds when it answers risk, not only innocence. Agreed? A bail draft succeeds when it answers risk, not only innocence. Custody status, date, time of arrest, remand history, custody period, investigation is raised. This you have, or you should cover under this bail application. Arrest memo, remand order, medical papers, all you have to annex with your draft on this bail application. Offense gravity, punishment range, role, parity, nature of allegation, FIR, charge sheet, contact, co-accused orders. If there is any order in favor of the co-accused, that also we can annex with our document. This bail has been granted to him on these grounds. Investigation is cooperation, document already seized, no custodial need. We have to establish he will cooperate, documents already been seized, and no custodial need now. Notices, attendance record, seizure memo, that document you have to annex. Flight tampering, local route, employment, family, passport, willingness for conditions. We have to just show this. This is the roadmap. ID, address proof, employment proof, where he is working, his address proof, his ID, all should be annexed. Because if in any case the person is bail, he must be under the control, under the jurisdiction of the court. So therefore, just to make it sure that he will remain under the jurisdiction of the court, we have to annex all these documents. Humanitarian focus, age, illness, caregiver role, and special circumstances, that we can just plead before the court that his age, if it's a old aged person or it's a young person, I mean below 18 years of age, juvenile court will work in those circumstances. If it is he's only the caregiver, he's only the earning member of the family, in that way we are just pursuing before the court for the bail. Medical record, dependency document. If in any case we are showing that his illness or suffering, then we have to show the medical report and dependency document. Drafting discipline, do not argue the entire trial in bail. Be careful. We are just seeking bail. And bail, we are just showing that there is no need of the person to be remain under custody. So he should be bail out. And bail is the, maybe we can say bail is the right after 90 days in, matter which are compoundable. And after 90 days, once the matter are non-compoundable, if the investigations are not complete. But till the time the police can take in the custody. To show why continued custody is necessary, disproportionate, or legally unsupported. Anticipatory bail. The bail, first we were discussing about bail. Anticipatory bail requires a clean apprehension narrative and credible cooperation plan. What to establish? Reasonable apprehension of arrest. Number one. Nature of acquisition, lack of custodial necessity. Repeatedly, I am saying, first you have to show there is no need of the custodial arrest. There is no need of the, there will be no left from the side of the accused to attend the proceeding. He will cooperate in the investigation. There is no need of his custody during the investigation. No flight risk, no evidence tampering. This we have to establish. He will not do any kind of tampering. He will not manage or manipulate with the witnesses. He will not go anywhere without the permission of the court. This way we are pleading before the court. Willingness to join investigation, that he is willing to join the investigation as and when the authorities will call him. Personal circumstances and antecedent. What to avoid? Very important. Vague claim of political business rivalry without particulars. Correct? Unnecessarily showing that there was a rivalry and he's taking the revenge. Don't show it. The court will not happy with your that type of content. Aggressive attack or complaint unsupported by document. Although we are supposed to attack on the complainant on the basis of certain facts or certain document or certain reason, but don't create unnecessary or unsupported by document. If there is some document, reasonable reason to just establish before the court that the complainant is just doing the revenge and out of revenge feeling he is doing, you are not supposed to make this type of statement. Seeking blanket protection for the unknown offenses. Unknown offenses, if it is not declared, take the blanket protection that you have to avoid. If you are presuming that it may also happen, the thing may go up to that extent, that type of things you are not supposed to propose. Ignoring statutory bars or special enactment. Copying regular bail ground mechanically. See, all bail applications are having different facts and different circumstances. So please don't copy the bail application filed by any other advocate. It may be covering the other reasons for the bail and your bail may be different. So make your own drafting. Bail application should not be very exhaustive, very lengthy. It should be hardly 2, 3, 4 pages. But the content should be very good. Each and every paragraph should have the specific need and requirement of the bail and must show that he will not fly anywhere or he will not tamper with the documents. So such type of thing you have to mention. Suggest structure, jurisdiction, that the jurisdiction of this court lies in such type of matter, because the criminal matters, there are the jurisdiction of the court to which matter, to which court you have to apply. Apprehension facts that you have to show. Allegation summary, ground for protection, cooperation undertaking, prayer and condition. Correct? Question and discharge draft must separate legal impossibility from factual defense. Ground type, no ingredient, even if allegation are accepted, offense is not disclosed. Here you are applying for the question, right? One thing was the anticipatory bail, another is you are applying for bail, one is the question petition focus. So what should be the question and discharge draft? What should be discharged? Both are having the different, gravity. Once we are approaching to the question of FIR or question of on the petition, then the way we have to approach to the court, and one is the discharge. Discharge will always happen once the charge have framed. So don't move discharge before having the charges being framed by the court. So even if allegation are accepted, offense is not disclosed, material content does not make our charge. Make out the charge. Abuse of process, proceeding malicious, still retaliatory or legally barred in question petition. And continuing trial would be groundless on record. This is in discharge application. Civil criminal overlap, civil breach dressed as criminality without dishonest intention. Correct? This we can mention before the court. Civil breach has been covered in the criminal liability. So this may be one of the ground of the question. No material showing manslaughter at relevant time. This should be the discharge once the charge have been framed. Document contradiction, unconverted record, demolish prosecution story. Prosecution document contradict essential allegations, right? Those are not clear why this charge have been framed. So we are claiming the charges. Settlement compoundability, scope depend on nature of offense and public interest. So we should be clear if these are the compoundable offense in practicality under 320C IPC that time, and now please go with the provision, the compoundable offenses where the settlement are possible, and and may be relevant, but stage and stage will matter. But if the charges have been framed, it is difficult that the court will refer, but High Court has all the power even after framing of the charges to refer for mediation. So there is likely chances of the settlement. If it is compoundable offenses, the court can refer it for mediation and we can settle the matter. Drafting test, do not plead, I am innocent as a question ground. Plead why the proceeding is legally unsustainable or an abuse of process. Be careful. Don't repeat yourself as I'm an innocent person. You have to show ki why proceeding, why you are not liable, why your criminal liabilities are not being declared by the this complaint or the FIR. Complaint side criminal drafting must preserve evidence and keep the procedure route clean. Common complaint document, code drafting standard. Information to place. Now you are just making the complaint, correct? We discuss about the bail, anticipatory bail, and the defense we are taking, question or the this charge sheet, chilling the charges. So common complaint document, what should be? Information to place, representation of FIR for FIR. So whenever you are making a complaint for your client, be clear, everything should be specific. Date, time, offense, the person against whom you are making the complaint. FIR, obviously, they will draft the FIR. We are just giving the complaint, but the provision of the sections should be specific. If we are going to FIR, that time you can just see complaint before magistrate, protest, petition against closure, final report, application for further investigation, preservation of the digital evidence. Yes. Application for further investigation, preservation of digital evidence. If you are just looking at the need of the further investigation, then also we can move to the before the competent authority for the further investigation in the matter. Opposition to bail, cancellation or modification of bail. Once you are receiving an application, the accused has filed the bail application, that the court will definitely issue the notice to the other party, and then that time we are just opposing the bail, and then we have to cover everything why bail should not be granted, and all those things which he has mentioned, we have to oppose all those plead before the court that why bail should not be granted. Victim compensation, protection, application where applicable. So these are all the legal documents once you are just from the side of complainant. Code drafting standard, lead with offense ingredient, not outreach. Explain delay, if in any, with credible chronology. Annex proof of attempts to report or preserve evidence. Specify accused role, witness, document sources. Accused role, witness, and document sources. Documents are very important. See the document provided by your client are specific, clear, and they have authenticity. Correct? Avoid asking the court for investigation directions without factual foundation. Opposing bail requires showing concrete risk, not merely repeating allegation. Very important. Tampering, accused will influence witness. This we can just draft. Identify witness, relationship, prior threat, contact, and pending testimony. This should be as strong as you can. Flight risk, accused may abscond. Then, what are the stronger drafting? Show lack of routes, prior evasion, travel attempt, non-cooperation. What will be the weak drafting? Custodial need, investigation is pending. Investigation may remain pending for years. There's so many FIRs, so many complaints with the police, and they are doing investigation. So only just writing investigation is pending will not suffice the purpose. List specific recovery. Confrontation of digital extraction is still required. So this type of strong opposition is required. Gravity, offense is serious. Only writing this is not sufficient. Link seriousness with role. What was his role? What type of manslaughter he was having? The habitual offender he is. So such type of thing we have to show. Evidence, strength, and societal impact. Repeat offense, accuse is habitual. Just writing is accuse is habitual is not sufficient. We have to show how we are just claiming it that he is a habitual offender. Annex antecedent, pending cases, or conduct after offense. Digital evidence must be pleaded with source, chain, and certificate strategy. Digital sources, what are the digital sources? WhatsApp messages, email, CCTV, the stem, body cam, call detail record, tower location, bank, UPI, wallet record, cloud flies, social media, post, device season, and forensic image. All these are the digital sources. Drafting field, source, device, or platform. Date, time, and time zone. This we have to mention. Manner of extraction, कि आपको वो कहाँ से मिले, from where you have extracted it. Harsh integrity makers where available. Person with control of device system, certificate expert role. Need the certification for the same, because all these, this is the time of the AI, so we can create anything. So therefore, we have to establish before the court that all these evidence are all certified, and the certificate we have NS along with this. Screenshot without source, context, or certificate planning can become vulnerable at the stage of admissibility or appreciation. Use this criminal drafting checklist before filing any major criminal pleading. This is the checklist. Correct current code and section number checked. Please be careful about it. Role attribution for each accused is specific. So you can just write down the section of both the penal code. IPC under this provision, and now at present this section, so it's come under the BNS of this section, under this provision of the BNS. Role attribution for each accused is specific, very important. Against whom, what you are claiming, who has done what he has done, everything should be clear and specific. Custody, arrest, investigation stage clearly stated. Correct? Statutory bars, sanction, and special enactment checked. If we are claiming any of these things, then it should be checked. Tone is restrained and avoid scandalous allegations. How you are just, addressing the court, that tone is also very important. Not only drafting, your drafting tone as well as your tone of your voice also matters a lot. You are pleading for your client. So you should be humble. You should not encroach upon the power of the court on discretion. This bail and injunction, both are the discretion of the court. So how much you can convince the court, that is important. And the same you have to check in your pleading as well. How much convincing you are once you are just pleading for the bail application, right? How much you are having the tone of convincing to the court once you are filing a complaint. Then also, offense ingredient map to plead facts, delay if any explain, evidence annexation and digital record route plan. The way you are just going through the evidence, the digital record you are showing, there should be a numbering. And in chronological manner, you have to show that. So be careful about that. Prayer is a stage appropriate and realistically grantable. So that we have to show the court has all the discretion to grant me this prayer. And that way you have to just show the court that this is a court discretion as well as this within the jurisdiction of the court. Fallback relief and condition proposed where used. Where it is useful, definitely you have to mention. So these are some checklists. If you will just go through before filing your any criminal drafting, maybe the bail application, maybe the complaint, maybe the question, or maybe the charge challenging the charge sheet. So all these things you have to be careful about it. So this was all about the criminal drafting and wrong statute and section, group allegation, district carelessness, no ingredient mapping, and over criminalization. Most criminal drafting failure come from 5 avoidable mistakes. These are the important mistakes which generally happen with criminal lawyers who are doing their strategies are wrongly mentioned, or group allegation making, or any digital carelessness, or no ingredient mapping, which is very important, and over criminalization. If for a small offense you are just making so much of accusation, that will also not suffice the purpose. So be specific about the allegation and which provision you want to take up the matter by the court. That is important. Criminal drafting drill: improve a weak bail paragraph into a risk-based submission. Weak paragraph, improve paragraph. This is one of kind of example I have just drafted. The applicant is innocent and has been falsely implicated. The FIR is false and baseless. The applicant is a respectable person and undertakes to comply with all the conditions. Therefore, bail may be granted. Now, improved paragraph. The applicant has been in custody since such and such date. The material relied upon by the prosecution is documented and has already been seized. The applicant appeared pursuant to notice dated so and has permanent residence at so and so place and undertakes not to contact prosecution, witness, or leave jurisdiction without permission. See, the content, both the paragraphs are for the purpose of the same thing, but the content material a lot. The way you are giving the specification of everything. Okay, what is our takeaway? The improved paragraph answer custody necessity, cooperation, tampering risk, and court management conditions, not merely innocence. Only saying the applicant is innocent will not suffice the purpose. You have to just establish, mentioning all these facts. He cooperated, the notice he received, immediately appeared before the competent authority. He is the permanent residence. There is no repeat history. Like this way. So, civil drafting we have already discussed. Now this was a criminal drafting, and very quickly I have rushed. Today I am leaving for Jaipur. So I hope and I believe. I think it is clear.
Yes, ma'am. Yes, ma'am. It was perfect. I guess we finally concluded the other part of the session.
One more day I will again would like to repeat it because mind is somewhere else and I am doing some work somewhere else. So
No worries, ma'am. No worries, ma'am. It's totally fine. Ma'am, do we have time for 5 minutes of Q&A, or you are in a hurry so we can reschedule it?
so please, today I won't, not a single minute.
Okay. No worries.
Any
no
other day you can just fix it. I will
Yeah,
again,
I will just share your mail ID so students can ask their questions on your mail if
they
they
can
have it.
ask me, or any other day on what you do, just ask them to prepare the questionnaire on civil drafting as well as on criminal drafting. And one
Yeah,
session
yeah.
I put for question answer only.
Right.
I
Definitely,
may or may
definitely.
not respond on this thing, but I will
Yeah.
definitely get the answer to their queries. But
Yeah. Works.
one day we
Totally
will have.
fine. Totally fine,
And
ma'am.
Dhruv,
Thanks
if
a
you
lot
want
for.
any further session now, so please make out every month if you want or something, quarterly or whatever. You just make out my timetable because every time
Yeah.
so occupied now, it is very difficult. So I will have in my mind that I have to take that session. So
Yeah,
that
ma'am.
much I will
Definitely.
request him.
No worries, ma'am. Thanks a lot for taking today's session. I hope everyone had a great time. And thanks everyone for joining today on Sunday morning. It's very difficult to make out time for all of this stuff.
This is from my side also. If they are just attending the session and sincerely attending the session, listening. So this is very nice on their part. They are actually want to learn. So definitely, I would also like to share my small knowledge with all of them. So thank you so much. See you soon.
Yes. Thank you, everyone. Thank you, ma'am, for taking today's session. We'll conclude this session. Thank you, everyone.